Hi, everybody. Welcome to the webinar. I see people are still joining us, so we're going to give about 30 seconds to let everybody hop on, and then we'll begin. Okay, let's get started. I want to welcome everybody to today's webinar. This is the latest in our quarterly Privacy Watch series. I'm Lauren Bernard. I'm the marketing director here at McMurray & Shuster, and I am very happy to be joining the attorneys today for our session, Striking the Balance, AI's Impact on Consumer Data Privacy. So before we get started, I just want to do a little bit of housekeeping with everyone. First of all, this webinar is being recorded, and so if you need to hop off early or if you want to share it with colleagues or folks afterwards, you'll be able to find that on our website probably in the next couple of days. Secondly, the questions, if you have any questions, there is a Q&A box. Feel free to add those. I know we received a number of questions at the registration time, so we'll be getting to those, but anything that comes up during the session, please share them and we will try to get to them as well today. We would not be a law firm if we didn't have a legal disclaimer. So I just want to say that what you're about to hear today is not legal advice. Every business's situation is different. So we recommend that you consult your counsel for the legal issues that impact your business. I happen to know a couple of really fabulous attorneys that I'm sure would be happy to help you. Did I do that disclaimer right?
That was the perfect disclaimer.
Awesome. Okay. So with that, I want to get started, introduce who we have here today. Next to me is Michele Shuster. Michele is one of the founding partners of McMurray & Shuster. She brings a tremendous amount of experience with consumer protection law, right on the front lines, really all sides of these laws. Working as a consumer protection regulator, where she helped shape the regulatory landscape here in Ohio and across the nation. And now obviously working with businesses, understanding these laws and proactively complying and dealing with agencies when that comes up. You have a tremendous...
We work with the agencies.
They work with the agencies.
That's right.
She and especially with, telemarketing, lead generation, customer engagement, tremendous amount of experience in that area. And then joining us from his satellite office is partner Josh Stevens. Josh is one of our privacy gurus here, and so he works with our clients on a wide range of privacy laws, state laws, everything that's coming up, will be coming up. Josh, you've been pretty busy lately, I know. Don't see that
that's an understatement.
Anytime soon. But so between the two of them and their areas of strength, I think there's going to be a tremendous amount of experience and insight that we'll be getting on this topic today. So with that, I think, Josh, let's kick off with you, and let's start off by getting everybody on the same page with AI and what it is and what it isn't. I mean, we all talk about ChatGPT and some other things, but it's really interwoven into so many areas that we may not even be thinking about.
Yeah, ChatGPT and Bard seem to be catching all the headlines, but they're not the only AI products out there. And I think it's important when we're talking about AI to understand that it's really a fairly broad term. If you look at the way it's defined in European law and US laws, in other countries, the definitions differ, but the common theme is that it's using a computerized system to essentially act in a human-like way to make decisions or to predict something or identify something, to take certain actions that normally would require human involvement. And it's doing that using algorithmic or logic decision-making, machine learning, other technological tools without a human being having to go in and set every single parameter for that system. And so, we're talking about ChatGPT, we're talking about Bard, these generative AI type systems, but that's really only one type. There are also what we sometimes refer to as narrow AI systems, where the system is tasked with a specific use case and the outputs may be predefined by the user. I think of these sometimes as some of the chat bots that you might work with when you're on a bank's website or in a more advanced IVR kind of system, right? But AI stuff has been around for a long time. I think, Michelle, we were talking before the webinar about, a computer that learned to play checkers in the 50s, right?
Yeah.
These tools have been around.
Yeah, yeah. And it's interesting how now that we're in this world of artificial intelligence becoming commonplace. Just as an aside, I have to tell you, I was at an event over the summer, and there were a lot of teachers that were there, and it seemed like every time I met a different teacher, ChatGPT and artificial intelligence came up, because they really have no idea how to handle the output that is happening with their students who are submitting things, and they have a concern about their inability to learn how to research, which was just an interesting topic around all of this. But also along those same lines, with the output that AI is putting is generating, it's causing some concerns among the regulators. And the three areas that we're specifically going to talk about today, which Josh is kind of alluded to, is one, privacy, all kinds of privacy implications with the input into these systems and the potential output. Also telemarketing, we're seeing a very large number of AI enabled dialing systems, telephone systems out there. And there are implications with those state and federal telemarketing laws as a result. And then finally, the FTC has been very interested in artificial intelligence, lots of information, lots of consumer information that's coming out about it in the form of warnings. And we're going to, I'm sure, see much more business guidance out there soon. But when the FTC gets involved, it means that the AGs will as well, and that there will be consumer protection implications. And that's not just in marketing and advertising, that can be in credit reporting and other type of laws that are concerned with the potential for discrimination when you're making decisions for applications or rates or what information a consumer receives. So lots to talk about today. So let's get started.
Great. So let's say a business is going to be working with an AI product that's offered by a third party. What do they need to be asking their potential vendors? What considerations should they be taking into account?
Yeah, so let's start with the privacy lens. The first piece is, what was this system trained on, right? And did you have the right to use that data to train the system in that way? Because we want to make sure that we're using a system that was built in a compliant manner that respected the privacy rights of individuals whose data may have been put into that system, right? That's part of being a good corporate citizen. Second is, what do you do with the data that I put into the system? And specifically, in my mind, that's questions around, are you planning to use it as part of a training set? Does it become your property? With ChatGPT as an example, if you go and you look at their online terms for their consumer product, their free consumer product that's available online, you can't opt out of them using the data you put into it to enhance their product. So that raises concerns around the potential sale of data. And so you really want to understand, okay, what's happening with my data when it goes in? Then what does the output look like? How do you ensure that my data isn't getting exposed to other users of the product? Because I need to protect not only my confidential information, but the privacy rights of any individuals whose data I'm putting into the system, and make sure that that doesn't get shared with someone else unintentionally. And that's a bigger concern for generative AI than it is for the more narrow AI systems, because the generative AI systems are creating those outputs. And we've all seen the stories of what they sometimes refer to as hallucinations, right? Where the system either produces something nonsensical or it ends up spitting out something that reveals confidential information that was put into the system. And lastly is security, right? How is this system secured? Because we've also seen stories, particularly around generative AI, where sometimes users have been able, via the prompts they put into the system, to get the system to reveal information that the system otherwise shouldn't. And so it's essentially a manipulation of the system. And we want to make sure that it's secured against that, in addition to all the normal threats from malware and hackers and ransomware and everything else that's under the sun. So security is paramount to that.
Yeah, yeah. And if you look at what's going on in the telemarketing world and just calls in general, there's lots of concerns around that also when we're working with vendors. So all of those types of concerns that you would have with any type of voice service platform, you're also going to have with an AI platform. So, just starting with that, making sure you understand what the parameters are of that dialing system. Can this qualify as an automatic telephone dialing system under the Telephone Consumer Protection Act? Because it might be randomly or sequentially generating the numbers through AI that are going to be dialed, as opposed to dialing from a curated list. So I would think in most situations, the seller is going to be controlling that list or understanding how that list for calls is going to work, but you want to make sure that you don't unintentionally fall into those ATDS, automatic telephone dialing system regulations. And there are some states that have more strict requirements around what an auto dialer is, or more strict definitions. And so if it is automatically pulling a phone number from a list and then dialing it under a couple of the state's new mini TCPA laws, that could be implicated. So it's the same type of dialer issues we've traditionally had. They don't go away. But also, if we're relying on AI to handle the compliance component of our calls, and in particular telemarketing calls, there are a number of things that usually manually we set with each of those campaigns that you need to consider if the AI system is going to be handling those for you. So disclosures, we have to make sure that all of the required disclosures on the federal and state, which differ from the federal disclosures in many states, are being met by that system, that the system isn't calling outside of allowable calling hours. Certain states have days you can't call. They have more restrictive calling hours than the 8 a.m. to 9 p.m. on the federal level. So we have to make sure that those dialing times are have been correctly programmed into the system. There are states with registration requirements for systems that are called automatic dialing and announcing devices, which I think in many states, if you are using an AI-enabled system, it likely could fall under that. So there are registration requirements that your platform provider needs to have met to have registered that AD. Also, some states prohibit phone calls to unlisted phone numbers. Are we doing some type of scrubbing around that? Also, disconnect requirements. Is the system disconnecting within generally 4 or 5 seconds after the telephone call has terminated, which is a requirement. What type of caller ID is being used? Is the system generating that in some way, or do we have a caller ID that's being used that won't violate state or federal truth and caller ID requirements? So, when you're working with a vendor, make sure you understand the answers to those questions. Make sure that if you are delegating your compliance obligations to that system system is accurate. You really want to have a firm understanding of that. And then also, as we're going to talk about here in a little bit, you should assume for purposes of pre-recorded message laws that an AI system using an artificial intelligence voice is going to qualify under state and federal pre-recorded message laws. So we'll talk about that a little bit more specifically here in a minute.
Gotcha. Okay, so privacy risk, Josh. Risk is really on everybody's mind. What are the things that businesses can do to help mitigate that risk of using an AI product when it comes to privacy?
Yeah, so there are definitely a few things to keep in mind. First is the contract, and really going through that contract with a fine-tooth comb to ensure that you're not unintentionally licensing your data in a way that you didn't mean to make sure that the data security protections that you need are there, that they're indemnifying you for those risks, that they're upholding their compliance requirements under the law, making sure that contract has all the requirements for a service provider relationship, for example, under the California Privacy Rights Act regulations, which are very specific about what needs to be in a contract with a service provider. You know, if you are subject to, and I think we have a question coming, we may have had a question coming up later that I'm going to jump ahead to on specific state privacy laws. But if you're subject to those specific state privacy laws, and we have California, Colorado, Virginia, Connecticut in effect now, Utah coming up in December, many more coming up over the next few years, you really have to look at the system through the lens of those laws. So for example, if you engage in profiling or automated decision-making, which an AI system arguably would be, that results in legal or similarly significant impacts to a consumer, then under some of those laws, you have an obligation to perform a data protection impact assessment. And that's a detailed analysis of what it is you're planning to do, what the risks are, and how you're mitigating those risks. Consumers may also have a right to opt out of that kind of processing. So you really have to think through, okay, if I'm replacing a human with an AI to perform a critical function, so let's say like credit decision making, that would obviously be something with legal or similarly significant impacts. And if you're using an AI system to do that, then you want to do that DPIA. You want to figure out what opt-outs you have to offer and how you're going to have that human process that can step in where it can make a person can make those decisions instead of the AI. So having that as a backup. The other thing is, of course, around sale of personal information. You need to really evaluate whether the provision of the data to the vendor may unintentionally be a sale of that information. Because if it is, then you've got to revisit your privacy notices. Consumers have the right to opt out of sale in many states. And so that can have a huge impact as well. So what I recommend is, even if you're not required to do a data protection impact assessment from your use of an AI, do one anyway, because that will help elevate all of these different issues to the forefront of your mind so you can work through them and make sure that you're buttoning up what you need to before you deploy the system. Now, the reality is, as we know from working with many clients and from what we see out in the press, businesses already have these AI systems in place. So my response to that is always, well, late is better than never. So if you didn't do that kind of analysis before you started using the system, today's a great day to start it.
We'll give them till next week, Josh.
Oh, yeah.
All right.
So Michele, I'm going to turn to you a little bit and talk more specifically about telemarketing, customer engagement area. And I know we've got a number of clients who are already integrating AI into their operations. So with respect to some of the specific laws and regulations out there, TCPA, TSR, state laws, I know you touched on a couple of those in a previous answer, but what should these businesses be taking into consideration with respect to those laws and how they impact the use of AI?
Yeah, I think we start with the very simple and fundamental proposition that these artificial voice telephone calls are going to qualify as a pre-recorded message, or at least we should assume that they do until we can validate that they don't, that they qualify as a pre-recorded message or an artificial voice, as with the Telephone Consumer Protection Act starting out very broad here. It regulates calls that are made using an artificial or a pre-recorded message. And so from a TCPA level, we should assume that these calls that are being made using artificial intelligence are going to be regulated as such, a pre-recorded message or an artificial voice. And so that means that if we're going to be making telephone calls, and those are marketing calls, if we're making those to a wireless telephone, then we're required to have prior express written consents. I would think, seeing the list of folks that are on this call, most of you know what that is because it's been in the news a lot lately with some of the action from the FCC, but very specific language required in any type of lead generation form to get prior express written consent. If we're calling landlines, and it's also a pre-recorded, it's a pre-recorded message for telemarketing purposes, also need prior express written consent. If it's an informational call, generally it's just prior express consent. If we're calling a wireless number, meaning that the person that you're calling must have given their telephone number to you, and that you're calling them in the context that they gave you that cellular or wireless telephone number. And then for landlines, generally there's no consent that's required for the informational marketing calls. On the state level, I think it's important to know that like the TCPA, they also regulate telemarketing calls and pre-recorded messages pretty exhaustively. But political calls also on the state level are have regulations against the use of, or have specific requirements for the use of pre-recorded messages. So even if it's not a telemarketing call, if it's a political call, in some states there are some additional requirements. Also when we're talking about the use of pre-recorded messages, I mentioned earlier that on the state level, they regulate automatic dialing and announcement devices, which have always in the past been viewed as just pre-recorded message systems. And it's the system that's regulated, not so much the call and these 8080 regulations. And as I mentioned, they require registration, but then there are some additional requirements also for the content of those types of calls, including identification disclosures and those types of things. So, we should go into this just assuming everything that you already know about pre-recorded messages is going to apply to AI. Now, we haven't really had much out there in the litigation area around AI yet when it comes to telemarketing, but I anticipate we'll start to see many more cases that will be addressing any of the unique AI issues as time goes on and more companies are using AI. Also when we're talking about using AI, and not just for telemarketing, but maybe interaction online, the FTC has been very concerned about making sure that individuals know that they're not interacting with a human being. And so they haven't given a lot of guidance around that, but it's something that you should work with your legal counsel on if you're using artificial voice that is very human-like, because there may be some disclosure requirements around that. And that's something you're going to want to make sure based on what your particular campaign is.
So Josh, you kind of touched on this a little bit, speaking of state laws on the privacy front. You talked about it a little bit earlier, but are there unique issues that are hit on in addition to what you talked about before with state privacy laws and the use of AI?
Yeah, so, I think it's the ones we talked about before, where we're going to be expecting to see more regulation coming down around profiling and automated decision-making, which would affect AIs. We're expecting California to issue some more detailed regulations around that. We've seen interest from regulators in Europe and here in the States in potentially requiring some pretty significant disclosures around the logic of AIs, so that, especially the ones with legal or similarly significant impacts, so that users can understand really how they're being evaluated and what kinds of decisions are being made about them. And the concern is discrimination. This goes to, it's less a privacy concern as a discrimination concern. And this is something the FTC has brought up as well. that these AIs that are making important decisions about credit, or whether a landlord is going to rent to someone, or whether you get access to a utility or cell phone service, or things that really impact a person's life, employment, they need to be done in a way that does not discriminate against people based on a protected class. And there was a case in the news about a company, who I'll leave nameless, but they used an AI system to review resumes, and it came out that that system was scoring resumes from women lower than it was scoring similar resumes from men. And when they went back and they dug into, as part of the lawsuit, why this was happening, they discovered it had to do with the training set. The data that it had been trained on had been very heavily male resumes, and the resumes that it had been told were good resumes were also predominantly male. And so it drew, because it's trying to come up with what it thinks are the right things and the wrong things in resumes, and it drew an inference that men were better candidates than women. And no one programmed it that way intentionally, right? This was an unintentional outcome of the way it was trained. And so this is one of the big risks with these AI systems, is, the old saying, garbage in, garbage out. If the training set is not comprehensive enough, if it's not diverse enough, if it's not varied enough, then you can end up with a system that has these bad outcomes unintentionally. And that's where, in some of the privacy laws, and you see this in GDPR, for example, having that human opt-out, right? So being for the consumer to be able to say, you know what, I don't like this decision that was made. I know this was made with an AI. I want a human to review this, right? And then it goes over to a human for a second review. Those are important systems to help prevent these discrimination issues.
Yeah, important protections. So we got a lot of questions in during the registration process. I believe many of them were answered during the course of what you two have shared so far, but there's a couple additional ones I want to throw your way. So first one is, if an AI gains access to private information and somehow publishes it publicly, does it then become public information? What protections are there should this happen, especially given that the data could have been copied and many parties don't respect protection laws? I'll toss that to you, Josh.
Well, bad news, just because something ends up in the public domain doesn't really necessarily mean it's public information. So let's take a couple scenarios. And by the way, I'll just remind everyone, I think we are taking questions live as well. So if anyone has questions, to certainly submit them. So a couple scenarios. Let's take first off the situation of confidential information. So if, say, you're a business and you have your own confidential information and you're using an AI system, and that AI happens to spit out your confidential information as an output to someone else or in the public domain, there's an argument that you may have waived some of your protections to that data. And this is, again, where the contract becomes very important, right? If the contract specified that the system provider and the system had to protect the confidentiality of that information, then you may be able to argue, no, I really didn't waive my trade secret protections. They messed up. We're suing them. We're going after them, right? This is still supposed to be protected information. The flip side of that is, say you are a service provider to a client, and you've got that client's confidential information and you put it into an AI, and that same scenario happens where it spits it out into the public domain. Well, now you may have breached your confidentiality obligations with your client because you didn't properly secure their information. So this again goes back to really understanding how the systems work and what protections are in place. because you can end up violating your confidentiality obligations. The other piece of this is there are some exceptions to the definition of personal information for publicly available information in some of these new state privacy laws. Those definitions are pretty specific as to what constitutes publicly available information. It's typically stuff that comes from a public government database like a recorder's office, or it's information that a consumer has put out themselves into the public domain without any indication that they were meant for it to just be viewed by a limited group. So like if you have a LinkedIn profile that is public, what's on that profile might be publicly available information under some of these laws. But if you have, say, a Facebook profile that you only allow your friends to see, then that wouldn't be considered publicly available information. So the fact that your personal information gets out through an inadvertent output of an AI system doesn't mean that now all of your protections as a consumer to your personal information are gone.
Gotcha. Next question. Considering generative as user-driven prompts, will entities be liable for consumer input that results in possible false data? And can poorly implemented AI logic cause brand liability? So again, the liability risk, what do you think about that?
Yeah, I'm actually going to go to Michele on this one because I think this is really a big UDAP issue.
Yeah, we haven't really talked much about the UDAP issues here. And just so everybody knows what UDAP means, because we use so many acronyms, it's unfair, deceptive acts and practices. And the body of law for UDAP really initiates with the Federal Trade Commission's FTC Act, and specifically Section 5 of it, which generally prohibits unfair and deceptive acts or practices in the consumer marketplace and consumer transactions. And so, you know, when we're looking at this, you know, type of liability potentially for information that goes in and comes out of the AIs, we are looking at huge potential for consumer protection types of violations. Those being that we are putting out information that is not accurate, that it's unfair, that it is deceptive. And just because it was generated by an AI that you put together and not specifically drafted by your pen or your keystroke doesn't mean that there wouldn't be liability around that. The FTC has been very interested in these types of issues for a while now. They've had a few public meetings where they've sought input from experts in AI and consumer advocates around these types of things. And as Josh and I talked about before this, it's not just a black box that you're throwing out there that gathers information that you can use for any reason without any check or any liability for the output that comes from that, is what the FTC is saying. So there will be responsibility for those that are responsible for the AIs. We already know that that Congress is looking at these types of issues. You know, some of the legislation that's been thrown around out there is that you would be, and this is not law yet, but these are the types of things that we hear Congress talking about, that you would be required to identify who trained your algorithm and its intended audience, a very specific type of regulation targeted at these UDAP types of laws. Also, the disclosure of your data sources that could go towards privacy very easily, an explanation of how you arrived at certain types of responses that could be unfair or deceptive. You know, being required to answer those types of questions. And then also lots of legislation out there right now that's really trying to impose transparency around AI and putting strong ethical boundaries around it for the types of decision-making that Josh has talked about earlier. So the fact that it's AI and that it may not have been a human that generated the exact answer, we don't see any scenario in the future where the regulators would let that go as being not a violation because it was machine learned response versus a human response. So, you know, as as these AIs are being developed, they'll have to be very careful about what's going into it, and they'll have to have folks that are doing some type of monitoring and some type of testing to make sure that they aren't running into these types of issues unintentionally. Anything else, Josh, that you know, maybe more from the privacy perspective?
Well, I really more from the UDAP perspective, but I think the issue of what if a consumer asks a question in a poor way, right? We all know consumers can ask the same question with 1,000 different wordings, right? And so if the system creates an erroneous response because of the way the question was asked, I still don't think it's going to get you off the hook. The regulators are going to expect that the system is intelligent enough to be able to discern, like a human agent would, what that consumer was trying to ask. And I think this is an area where AI still has a long way to go with being able to just discern those cues and discern from the interaction with the consumer what they're struggling with, what words they're maybe not quite understanding, so they're not wording them right. But in a real face-to-face conversation, you can figure out what they're trying to say. And I think that's an area where AI still struggles a bit. And you hear consumers all the time talking about how they're frustrated when they have to talk to these computer systems, because the computer systems, they don't understand what they're trying to ask, right? Because they're not wording it in the way that the computer was trained, that the AI was trained to pick up on. And so I think, if you're going to use a system, particularly like in a contact center context, to replace human agents, you got to really test that system and put it through its paces to make sure it can discern what is being asked of it and can give that accurate response.
Yeah. I just think of the trouble I have with Siri. I think that's given us all a little PTSD for being maybe a lack of patience that we should have with the machine learning that we're being introduced to. But yeah, really some interesting scenarios, and it brings back a situation that we encounter frequently in the UDAP world, and that is the reasonable consumer, right? So even if you're trying to train your system so that they are interacting with a reasonable consumer, what most people would define as a reasonable consumer is way too high of a level of expectation for what a regulator would define as a reasonable consumer, which usually fits more of the least common denominator type of equation. So, this is a theme that has been difficult for us when we have human interaction, and it's amplified obviously from the types of scenarios that Josh has talked about in the AI world. It'd be interesting to see where that whole body of law with reasonable consumer interaction in an AI develops.
I might argue too that the more frustrated the consumer is becoming, the less reasonable they become. So
that is true.
Yeah. Okay, so I'm going to ask you folks to pull out your crystal balls. We like to do that. It's not Q4. Q4 is our crystal ball time, and we'll get to that. But I know that this is such a fast-moving target. It's just breakneck speed right now. But where do you see regulation of AI products heading?
Yeah. There was a report that was issued by the Congressional Research Services not too long ago that was a research of generative AI applications and where they were and where they were going. And the one very strong conclusion that they drew, and I think all of us are already probably aware of this, but their research confirmed it, is that most of the systems don't disclose where they are acquiring the data from, or if or how they acquired consent to use that data, and how they're using it for training purposes. And so I think that a lot of what we see in the future is going to be around those types of issues. Now, I also think that we'll see more TCPA litigation around artificial intelligence as it becomes more popular. It will be the pre-recorded message lawsuits that we are seeing an awful lot of right now. So it'll be important for the listeners of this to understand that it's really critical that they comply with those types of pre-recorded message laws. I also think that the FTC will be on the forefront of this, as they generally are, probably hand in hand with the state attorneys general. We have seen the FTC use a very large swath of different enforcement tools and to put industries on notice. About a year and a half ago, there were the notice of penalty offenses letters that were sent out to all of the large consumer products corporations that were selling direct to consumers about their endorsements and testimonials on their websites. And so I could see in the future that the FTC would be issuing those types of notice of penalty offenses again for AI, for those platforms around the issues that we've been talking about with consent and how they were programmed and those types of things. Also, I see liability for AI developers in the future for the exact same reason as the FTC will be interested in those issues as to how those are being developed. Josh, what about you?
Yeah, from a privacy perspective, we're certainly going to see more regulation around this. I mean, it's inevitable. The question is going to be, what does that regulation look like? So, for example, in China, their AI regulation that they're working through is very heavy-handed. It requires, it's basically a licensing regime and requires the businesses that are developing the AI products to disclose very detailed information to the government about those products and how they work and how they were trained and their use cases and so on and so forth, and in order to be licensed. And that's a pretty heavy regime. In Europe, we're seeing AI regulations being developed that are certainly quite aggressive. And in fact, even here in the States, there was, I saw an article the other day from, I forget which senator it was, but was commenting that perhaps we need a licensing regime here in the US, especially if the AI is a high risk, what they're terming sort of a high risk. And that would be like making credit decisions or employment decisions, things like that. Or, I was talking to someone with a healthcare company who said, if I use an AI to diagnose someone, that diagnosis had better be right, because that's going to be awful if that diagnosis is wrong, right? And so that's another area where, like, okay, that could be a high risk, and it'll be interesting to see how it shakes out. I'm not confident that Congress will come up with anything anytime soon. Congress has been pretty much a logjam for the last 2 years.
I can't imagine that you would say that. Yeah. I don't think half of them know what artificial intelligence is, but yes.
Right, yeah. So I think it's going to be at the state level that we're probably going to see the regulations coming up first, right? It's going to be from agencies like the California Privacy Protection Agency or the Colorado AG or other state legislatures or regulators. That's where I think the regulation is going to come up. But then we're going to run into the same problem that we ran into with TCPA and we're running into now with privacy legislation, which is you're developing a patchwork of different requirements from state to state. And while that's wonderful for us lawyers who you have to pay to try to discern all of that, it's horrible for our clients. And so, to the extent that anyone can push for uniform federal legislation or uniform federal regulation that is sensible, I think that would obviously be great. So that's my sales pitch for anyone who's watching the webinar, to talk to your legislators, talk to regulators, make your voice heard as to what you would like to see with regard to AI regulation moving forward.
So a lot covered today. It feels, obviously it's a conversation we're going to be continuing to have. I feel like 5 questions get answered today and 10 more are going to pop up tomorrow. So we'll be there. Obviously tracking this, working with our clients, trying to help, decode a lot of what's coming forth. Thank you, Michele. Thank you, Josh, for both of you joining me today with this. And thank everybody for attending. Just a reminder, the recording will be available in the next couple of days on our website. You can subscribe to our news and insights to just get more information on this and other topics, other consumer protection compliance topics that we talk about. You all know what we talk about all the time. You can do that on the website, mslawgroup.com/subscribe. Any additional questions, of course, Josh and Michele are always here and available to help. You can reach Josh at jstevens@mslawgroup.com. Michele is at mshuster at mslawgroup.com. I think that wraps us up for the day.
Thanks for spending your afternoon or morning with us.
Yes, thank you all. And Lauren, thank you for hosting.
My pleasure. Have a wonderful rest of the day, everyone.